Well, hello there. Thanks for joining me. I am Dr. Jens for the Australian state Tasmania. And I gotta tell you, I love doing these global location episodes because everybody does stuff a little bit different. But when you jump outside of North America, it just seems that much different. You're going to see that as we go through this today. Now, I have not taken a deep dive at these items that we're going to talk about, but you'll see that the framework is the same as any other location specific episode that I've done, which all of them are the same format. I explore basic four questions. What are the basics of this location's residential tenancy laws? And then two, what are the nuances of this location? What's different? What stands out? Three, what's some guidance on abandoned items left behind by a tenant in this area? And four, where to get help in the local area for landlords, right? That's the whole idea of this. As you see me answer these questions, I'm going to share screen with all kinds of documents specific to this location, as well as check off items on my bingo card to see what each location has, what they don't, what's different. And over the many years I've been doing these episodes and traveling, I've created a bingo card of standard items I see most often in tenancy laws in these different locations. Then at the very end of the episode, I'll go through that bingo card to help you figure out what you need to research more, especially if you have questions and you're a landlord in that location. But I must tell you, here's the disclaimer. There are more guiding documents than what I'm giving you here. This is not everything. This is not comprehensive. Even if I get it 100% right at time of recording, 5 minutes later, laws can and will change. There may be other things in your local state, province, county, territory, city, things like registering your rental. Maybe you have to be licensed. You won't know unless you dig up more than what I'm going to tell you here. This episode is not all inclusive, but it's designed to get you started. Okay, so for Tasmania, I am going to screen share. In fact, I'll do that right now. Give me a sec here. Share. Screen share one of the many hyperlinks I have, three, four, five, six, eight hyperlinks today. And if we find some other locations that are actually really cool, some other resources, I'll add them. But if you look at screen, if you're looking at My Life as a Landlord on YouTube, you will see that we're looking at the Residential Tenancy Act of 1997 for Tasmanian legislation, the Tasmanian government. The website is www.tas.gov.au. And this is the legal part here. Now it says amending instructions. Okay, hang on a second. Let me go in here. Preliminary. And this is the law, right? And so typically when I do these location specific episodes, we find the actual act or code or whatever it is that is the actual law. Then that's usually not very user friendly. Sometimes it is, but sometimes it isn't. Sometimes it jumps around. And then there's usually a user friendly, like user guide kind of thing. And that's typically what we'll find. And there's a couple of different resources that we'll go through here. And then we'll get into abandoned items and where you can get help. Okay, Residential Tenancy Act. So this is defining the act, all of the terms here. Oh, gray water, that's interesting. No, they talk about different things, payment period, rent, rent assistance. All of these are defined. And yeah, cool. Very cool. Social housing. This is talking about COVID-19 emergency periods, application of the act. Okay, then that's all of that. I'm just going down to the part two, residential tenancy commissioner, residential tenancy agreements. Let's see what we got here. Okay, residential tenancy agreement exists where a right of occupancy of a residential premises granted by the owner of the premises to a person for value. Oh, that's cool. All right. And it's talking about its fixed period, so it ends abruptly right on the end of the, as they say, expiry agreement, and you have to establish a new one. That's on the bingo card for sure. Variation, written agreement, written residential tenancy agreement has to be easily legible, clearly expressed, and if printed in 10 points or more. Now, these are like font points. Usually it's, if you're looking at a regular document, that's usually written in like 12 font, size 12. And so this is really interesting that they actually say the size. That tells me that somewhere along the way, somebody did like a micro print one and that was deliberately too small, right? So they're saying it has to be legible. The owner is to provide the tenant of the residential premises to which the residential agreement relates with a copy of the agreement within 14 days. That is definitely on the bingo card. You've got to have within 14 days. The lease delivery, yeah. And you can't be making agreements or saying things in the lease that are contrary to the act. That's pretty standard. That's called unconscionable. You can't do that really anywhere. I haven't seen that anywhere. Money other than rent. Now, here's an interesting thing, penalty units. It's talking about penalty units, and there is a value to the penalty units. So let me back up here. It says a person must not require or receive from a tenant or prospective tenant any money or other consideration for entering in, renewing, extending, continuing residential tenancy agreement other than rent in advance, a security deposit, or a holding fee, and the fine not exceeding 50 penalty points. So let's define a penalty point in Tasmania because the last time I looked, it was about $200 US. Um, the current penalty unit value is 205. Yeah, so 50 penalty points, or sorry, 50 penalty units would be $10,250 Australian. Okay, and that's roughly on par with Canadian dollar. But let's see if we go 205. Actually, let's just do a currency converter. AUD to USD. So if we did 10,250, that's roughly $7,200 US. And it's roughly the same for an Australian dollar is roughly on par with Canadian dollars. So just for my Canadian listeners. Okay, well, that's interesting. And so you've got to be careful. And so what that ends up doing is they'll say 50 penalty units in the act, and then year to year, they'll change the value of a penalty unit. That's kind of interesting how that works, right? That's very different. In fact, last year I had done a location specific episode in Queensland that had a different value for the penalty unit. So I know it wasn't up over 200 when I did it last time. So check the library if you want to know more about Queensland, but it does change the penalty units. That's the only place I've seen this so far is in Australia. Okay, and then we keep seeing more penalty units here. You're not allowed to take unreasonable fees. Rent collecting agency must not require a person who pays rent in relation to the residential premises to pay a charge or fee relation to rent or receiving the rent. Yeah. And then it defines a rent collecting agency or a water consumption charge. Okay. Increase in rent. Here, this is good. So you've got an owner by written notice to the tenant may increase the amount of rent payable to the tenant in respect to residential premises if written residential tenancy agreement for those premises allows for an increase and there is no written residential tenancy agreement for those premises. Basically, there's no lease. So either it's agreeing to have a rent increase in the lease or there is no lease. And then the notice is to specify the amount of rent as increased and the day where the rent increase takes effect. Now, it looks like you've got to give proper notice, which is standard as a landlord. It says social housing. So, social housing, if you're going to do a rent increase in social housing, the rent increase may only take effect from that day, 60 days after the day on which the notice is given, not less than 12 months after the residential tenancy agreement was commenced or extended or renewed. And if the rent has increased previously more than 12 months after. So it looks like you can only do it once a year following the first year of tenancy, which again, many of this is quite standard, except for a few places. Okay, receipt for rent paid, post-dated checks, unreasonable increase. So a tenant may apply to the commissioner, and it looks like the commissioner for residential tenancy commissioner for an order declaring that an increase in the rent payable under Residential Tenancy Act is unreasonable. So if a tenant's got to do that, they've got to apply to the commissioner and pay the fee, which, okay, if it's really unreasonable, then maybe paying the fee is worth it. But you got to weigh the grief to dollars ratio in that one for sure. And then the commissioner will weigh in whether or not it's considered reasonable or not. Okay. Distress for rent prohibited. A person must not levy or make distress for any amount due that is unpaid. Basically, you can't seize any of the tenant's goods. Like if they have a patio set that's worth, a couple grand, the landlord just can't go up and take their patio set, for example, in exchange for back rent. You cannot do that. And again, fine not exceeding 50 penalty units, but you cannot seize the goods of any tenant in exchange for rent or distressed rent. It talks a little bit about paying rent in COVID-19. Security deposits. Here we go. Uh, an owner may require that an amount paid by or on behalf of prospective tenant as security for the performance of obligations under residential tenancy agreement. And let's just see how much it is. Basically, it's got to be reasonable. Here we go. This is where Tasmania has an authority, has a residential housing authority, looks like. Is that what it's called? The authority. Let's see, it goes to the authority. Basically, what the landlord has to do, the owner has to do is the tenant will pay the owner a security deposit and then or the property agent on behalf of the owner must deposit that money with the authority within 10 working days after receiving it. Yeah. Okay. You can only charge one security deposit to be paid, and you cannot require an amount to be paid a security deposit that exceeds 4 weeks rent payable. So it's basically one calendar month of rent. Now it is common to have rents be paid weekly in Australia. I do remember that from Queensland as well. And so they do have monthly and longer tenancy agreements. The authority. Okay, gotcha. Okay, condition report. If an owner requires an amount as a security deposit, then you must do a condition report. The owner is to give the tenant 2 copies of a report stating the condition of the premises on or before the day which the tenant occupies the premises. And the condition report is to state the general state of repair condition, premises which it relates, and signed by the owner. And on receipt of the copies of the condition report, the tenant is to sign one of the copies and return one to the owner. And but it doesn't say that they have to do the condition report together. And that's typically how it works in North America, both Canada and the US in certain locations, right? Like you'll see if you're in the library, you're going to see there's a lot of folks that do this different, a lot of locations that do this differently. Okay. But the landlord does not keep the security deposit. It's actually turned into the state. Okay. Claims against disbursement of the security deposit, claimed by the owner. This is additional damage other than normal wear and tear. And then basically what they're saying is that the disbursements of the security deposits, the tenant has to make a claim to the authority that the contributors where the residential tenancy agreement has been terminated and the tenant has not lodged a claim with the claim form with the authority within 10 days after it was given to him or her, and the owner has not lodged a claim for the authority, meaning if the owner has more damage above normal wear and tear, they can make a claim, it looks like within 10 days, or the tenant has to actually make a claim to the authority to get that money back. But it's interesting because both parties actually have to claim to the authority to get any money back at all, right? Like this is the tenant's money. And so the landlord's got to be really prepared to make that fight because they're not keeping the money, right? And I guess in that respect, the North America in general, Canada and US, the landlord keeps the security deposit in some way, shape, or form. Some places they actually have to put it in an escrow account, or maybe they put up a bond. But almost all places in North America, the landlord will hold the tenant's money, which gives them a leg up, right? It's very interesting. Um, yeah, that's definitely unique. Okay, and then they talk about lodging disputes, appeals, unclaimed security deposits forfeited. Oh, the authority may determine in relation to a security deposit if a security deposit is held at least 6 years since the end of the residential tenancy agreement. So why would that happen? Probably either the tenant has forgotten, or maybe the tenant has been incarcerated, maybe the tenant died, maybe they're incapacitated, they've gone into long-term care of some kind, the family forgot, the estate forgot, and then basically the authority will, looks like it'll go back to the state. It doesn't go anywhere. Holding agreement and fees. Okay, so here's talking about fees. The owner of the residential premises that are unoccupied and a prospective tenant may enter an agreement to hold the premises for future occupancy of the prospective tenant for a specified period exceeding 7 days. The holding agreement may impose a fee payable by the prospective tenant as a condition of the holding agreement. Now, this is different than an application fee. This is holding the unit for the tenant, right? Especially if they're going to take it, let's say today's March 2nd, and I want to rent the my open unit for March or for April 1, and this tenant doesn't want to take it until May 1. Well, there's a holding portion there. Now, I may not want to do that, but if I did, or maybe I wanted to rent it from March 15th and the tenant wants it for April 1st. And so there's definitely holding because there's a loss of rent, right? There's a loss of rent to me as the landlord. So that's, they do actually do a separate agreement in Tasmania. That's different. Okay, and then it talks about repairs and maintenance. This is pretty typical. Urgent repairs, essential function of the unit, the costs, emergency repairs, basically anything that requires 911 to be called, reimbursement of repairs, and then order for repairs, especially if the state has to get involved. Okay, so that is all of that. Let's go into, oh, they have a part about smoke alarms. Okay, let's go into part 3A, smoke alarm. Relevant periods, maintenance and smoke alarms, removal of or interference with smoke alarms. Basically, a tenant's not supposed to do that. And there's a fine, not exceeding 20 penalty units. So that's basically what, 2 grand Australian? And then right to install smoke alarms in strata title units, so like condos. And then in in the US, when you have a strata title like a condo, like a CPR regime, then you've got they call it homeowners association or apartment owners association. But in Canada, it's called a strata. But in Australia, it's called a body corporate. It's all the same thing, just a different label. So they're saying that if a unit is owned by a strata, that the body corporate can go in and install the smoke alarm. That's why it's talking about there. Okay, minimum standards for the premises, cleanliness and good repair, weatherproof and structurally sound, bathrooms and toilets to be provided. I hate to say that, but I just am kind of shocked that that's what has to be put in. Cooking facilities, electricity and heating, and then window covering. That's typical. That's typical for blinds that you've got to be able to have some kind of blinds or drapes, something. And then ventilation. Okay, next part 4 is termination of agreements, and then we'll move on to the next one. So this is talking about everything that is going to potentially interrupt having the agreement. So the first one is delivery of the vacant possession from the owner to the tenant. Like, let's say there's a renovation that's going on and they're not going to make it. The contractor, maybe materials got delayed or the contractor got sick or something happened where the unit isn't actually going to be physically available for the tenant. That's a problem. Let's see, delivery of vacant possession of the premises by the tenant to the owner following the notice to vacate by the owner. So the owner wants the unit back for some reason, whether it's, personal living. Delivery of vacant possession of the premises by the tenant to the owner following the terminate notice to terminate by the tenant. So either the owner's given notice or the tenant's given notice and they're not able to deliver it. Order of the court making an order of termination in accordance with the Family Violence Act, like something is not safe. Public Health Act, the unit is not safe. Death of the tenant, there is no surviving tenant in relations. Yeah, we know we talk about death and aging quite a bit on this show. That's important. Ends the tenancy. And then recovery of vacant possession of the premises by the owner following abandonment or early vacation of the premises. And so notice of the termination by tenant. So it looks like the tenant has given notice. There's a hardship, a court stuff. Like if you're a landlord in Tasmania, you need to get into this yourself. And there's hyperlinks all through this. And we haven't gotten into even the second resource yet, but I wanted to at least go through this in overview here. Order of termination, notice to vacate by the owner. Let's get down to, so it defines if an owner is going to give notice to a tenant to vacate because someone in that owner's family is going to move in, it actually says who the member of the family of the owner is. The owner's domestic partner, son, daughter, or parent, parent of the owner's domestic partner, or another person who normally lives with the owner and is wholly and substantially dependent on the owner. And so, yeah, it is basically an immediate family member, some son or daughter or parent of one of them or someone who's fully dependent on them. That's it. So it's not like, extended cousin, Aunt Mabel. No, can't do that. And then there's a bunch of different notices of the different reasons on how many days. So the days really matter in the notice. Wow. Okay, and then it talks about notice to pay rent, rent in arrears, failure of paying rent. That's one thing we haven't seen yet. We haven't seen a late rent payment or if there's a grace period or anything like that. Okay, so here it's talking about abandonment of the premises and goods. This is good because this is part of our framework here. Residential premises are abandoned if the tenant ceased to occupy those premises and a notice of termination has not been served in respect to the premises and a notice to vacate has not been served, but ordering the declaring of the abandonment, the owner has to apply to the court, may apply to the court for an order declaring that the premises are abandoned. And if satisfied that the residential premises are abandoned, the court may take order to that effect. Vacant possession of the residential premises occurs delivered to the owner as of the date of the order. So remember, the goal of any eviction or abandonment is to get the unit back. But what about all the stuff? And that's what we're going to talk about too. So this allows the court order for abandonment will allow the owner to go in and change the locks, right? Okay, disposal or sale of abandoned goods. Here we go. This is the good part. Now, typically when we're talking about abandoned goods, we're looking for two different things. The first one we're looking for is some time period where the landlord is concurrently either inventorying items, storing items, trying to get a hold of the tenant. We're trying to figure out what to do with these items, but the whole time they're also trying to get the unit re-rented, right? So you're dealing with this person's items. So the first thing we're looking for is a time. And then typically the other thing we're looking for is a dollar amount. And there's usually some kind of dollar amount below that threshold is considered disposable. Like you don't need to either inventory, like there's some kind of action below that amount that it's like I said, considered worthless, even though it might have some value. Or above that dollar amount, there may be some value either in resale, a claim, maybe an insurance claim, maybe value to the owner. But we'll see what we're looking at. But those are the two things we're actually looking at in this instance with abandoned goods is we're looking for a time and we're looking for a dollar amount if they have one here in Tasmania. Let's see. Okay, disposal of or sale of abandoned goods. If a residential tenancy agreement is terminated and goods on the premises to which the agreement relates appear to be abandoned by the tenant, the owner may A, dispose of the goods if they appear to the owner to have no value, right? So there's no dollar amount, but there's no value. Okay. B, sell the goods if they appear to have value less than the prescribed amount. That's a bit cryptic. I'm not sure I understand that. Or C, apply to the court for an order permitting the sale of the goods for the best price reasonably obtained if they appear to have equal or more than the prescribed amount. So I'm not really sure how that would work, but if they have like a very rare baseball card collection or something and you have it appraised, then you would very likely have to go to the court and say, here's the appraised value. I would like permission to try to sell it for this appraised value. I'm making an assumption that that's how it was. Okay, then continuing on in this, the owner is to verify the statutory declaration, the means of disposal of any goods under the certain subsection. Now, I'm not going to get into the subsection of that, but the proceeds of the sale of the goods are to be dealt with as follows. Firstly, the payment of any debt owed by the tenant to the owner. Second, in the payment of the reasonable costs of the sale and likely storage as well. And thirdly, any balance to be kept in an interest-bearing account for the tenant for a period of 6 months. So any sale proceeds, you have to keep it. And then last, if the tenant does not claim any proceeds of the sale or goods kept under that within 6 months, the proceeds become the property of the commissioner. So you're doing all this work for the state, and the landlord may be able to take a cut of that. Interesting. Okay. Boarding premises. We're not talking about boarding, so I'm not. Let's go down to rental deposit authority, and then we'll scoot to the next one. I think that, yeah, we're on one of the last bits here. Okay, rental deposit authority. The authority may have a seal and may be sued or sue in its name. Okay, so this is the group that can take the security deposit, rental deposit authority. Okay. The authority is constituted by the Director of Consumer Affairs and Fair Trading. And the functions of the authority are to accept, hold, and disperse security deposits in accordance with the Act, collect data on the residential tenancy market in Tasmania, which is important, conduct public awareness campaigns to educate parties to residential tenancy agreements regarding their obligations, and to carry out any other functions conferred on it by this act may be prescribed. Okay, so it's talking about authority, funds of the authority, account, and financial statements and delegations. Okay, well, that's kind of interesting. So it sets up how that all works because that's different than anything that we've seen. That's kind of, yeah, rental deposit authority. Rental deposit authority. Very cool. Different. That's why I like doing these. Okay, so then Tasmania has this thing, residential tenancy database. So they're storing information relation to tenancy. And let's see, it looks like they're capturing information about the tenant and the unit, storing information with, okay, let's see here. Personal information, including an individual's name or an opinion, whether true or not, about an individual whose identity is apparent, can be reasonably ascertained from the information. Okay. Section. Well, when your security deposit is turned into the authority, the owner's name and information is known, the rental unit is known, and then the tenant's information is known, right? And they may even want to see a list of the residential agreement, the lease. We'll see. But this is really interesting. But the owner or agent must, as soon as practicable, but within 7 days after using the database, give the applicant a written notice stating the name of the database, pertinent personal information, and the name of the information, how the in what circumstances the applicant can have their personal information removed or amended. Oh, this has nothing to do with the security deposit. This is just the database. This gets talked about all the time, by the way, on Facebook. In usually in America, in North America, typically in the States, but I do see it sometimes people in Canada talking about creating a tenancy blacklist, and that's exactly what this is. But if a landlord is going to make a report to the database, they have to notify the tenant that they've done so. And so it's sort of like your credit, which is kind of different. Um, I always thought that they should do that, actually. Hmm, that's cool that they're actually already doing it, which is different. Okay, ensuring quality of listing, database operator's obligation. You've got to make sure that everything in the database is correct. Now, if you're a landlord in Tasmania or you're operating in and around Tasmania, I want to talk to you because this database thing is really interesting. And this idea is brought up all the time, especially in the States. And so I'd really like to know about this because now we're getting into privacy and reporting and licensing because you're not allowed to do something without notification, which they apparently they're doing here. This is different. Okay, I think that, okay, so miscellaneous. Okay, so let's go into miscellaneous because there's a bunch of stuff we haven't talked about. Here it talks about subletting, transfer of residential tenancy agreement, tenancy ceases on the death of the tenant. Despite any other law to the contrary, on the death of the tenant, the tenancy does not vest in the heirs or successors. Yep. Use of the premises. You must use it for a lawful purpose and for a residential dwelling, and you cannot cause or permit a nuisance to be made from the premises. Responsible of tenant for cleanliness and damage. Yep, true statement. Quiet enjoyment, that's very typical. Oh, here's a different. Certain photographs to not be displayed by the owner. An owner of a residential premises must not, without written consent of the tenant, display a public photograph, film, or video recording of the premises that displays an object in the premises that may identify the tenant or another person. Hmm. Okay. So I'm assuming this would be for like listing the unit. If you're like walking through saying, "Hey, I'm going to take photos," and then they put those marketing pictures or a video out on like a website or an advertising platform like Craigslist or Facebook or something, and you can see like they're taking photos of the family, right? Yikes. Okay. Wow. Okay. You can't do any identifying markers. Okay, right of entry. Now this is called abusive access for a landlord. In Tasmania, they call it right of entry. Okay, so the owner of the residential premises must not enter the premises or permit any other person to enter the premises without the tenant's permission. And unless it is believed reasonably that a tenant is ill or injured and unable to give permission, denial of immediate access is likely to result in damage to all or part of the premises. There is a risk to the tenant or another person in present on the premises, or damage has occurred, or it is reasonably believed that the premises has been abandoned. And you've got to give at least 24 hours notice. It continues on about what business hours, right? You have to have reasonable business hours. Here it says 8 a.m. to 6 p.m. You have to give at least 48 hours notice in writing to the tenant, and you can't be just saying not more than more than 5 days in any week. Like if you're trying to work on something, you got to get yourself in there and get it fixed. Okay. Locks and security devices, they can't change it, either party without changing it without permission. Recording of the rent, notification of name and address, agent of the tenant. Okay. Keeping of pets. A tenant is not to keep a pet on the residential premises without permission of the owner, unless permitted to do so under the agreement, unless it is a service dog. Yep, that's pretty typical. Okay, I think We are there. That was miscellaneous. All right, that was just the first one. All right, we're going to go through. This is the rental guide for consumer building and occupational services for the Tasmanian government, a guide for property owners, property managers, tenants, and tenant advocates in Tasmania. Now, this one, I think we're going to end up going pretty quickly, and we're basically just going to hit the high points because there's a lot of things that we've already hit. Now, there's a couple things in here that I can see we didn't. Upfront entry costs, record keeping, we've done that. My bond, that's the whole idea of the deposit, how to lodge a bond, pay a bond, transfer a bond, claim on the bond. Um, yeah, I think we've got most of these, but let's go through. Here's more about abandonment, breaking the lease, notice to vacate. Yeah, I still don't see anything about late payments of rent. Here we go, paying rent. Well, let's just scroll down here. So, just taking a look, it talks about this policy, talks about the act, beginning a tenancy, what to do, fixed term agreements, or what to do without a fixed term. So, a rental bond, they talk about upfront entry costs. A rental bond, which is a security deposit to cost up to 4 weeks of rent, rent in advance of the first payment, and then a holding fee. Yeah, we've talked about this. The owner cannot charge for any other fees, such as an application fee or a fee to find a property for a tenant, right? So you cannot charge an application fee. Even if you're doing background checks, that's cost doing business in Tasmania. That's all right. And let's see, we're going to just scroll down here. This is the minimum standards, smoke alarms, maintenance requirements, condition reports, record keeping. We talked about this when we went through the original act. Now, they've got a program online about how to register the security deposit, which is called My Bond, which basically is what you're doing when you turn it into the authority. They didn't call it that in the act, but that is what it is. And so you've got to actually be a registered agent or property owner with the rental deposit authority and have active bonds uh, to have been registered with My Bond. If not, you have to re-register on how to do it. Now, there's quick reference guides on how to do this. They give you the website right there, and then how to lodge a bond. You need the tenant, the tenancy details, the property, the bond amount, how the bond is being paid, and how each tenant is paying if you've got multiple tenants. And then how to transfer a bond. This is if you're going to sell it to a new owner or maybe the property is being foreclosed on, then you can transfer the bond to a new owner. They're going to want to see the closing documents, of course. Or if you're going to change the management property, same thing. And then tenants moving in and out, tenant swaps, as they call. And then how to claim on a bond. And this is either the owner, the agent, you do it within My Bond, or if the tenant makes a claim because they're moving on to the next property. But a tenant may make a claim if the owner or agent has not made a claim within 3 working days of the tenant handing back the keys, or the owner has not indicated they will make a claim. 3 working days. That is quick. Wow. Wow. So start a claim against their part of the bond if the owner agent has not done so within 10 days of giving the keys back. So you basically have 3 working days to either make a claim or tell the tenant that you're going to make a claim. And then you have 10 days to make that claim. And then it talks all about how to do a claim, how to dispute it, how to upload evidence. Okay, rent. Rent can only be increased 12 months, regardless of the date the agreement was signed, which is pretty typical. Increases of payment. Rent can only be increased if there's a written lease that allows for rent increases, and then how much it's going to be. I wonder let's just go and say, how much can a rent increase be in Tasmania in 2026? Let's just say. No specific maximum amount for rent increases. It largely depends on market local rates. Okay. So it doesn't actually have an amount there. There's no calculation. And I did not see a late fee either. A late fee or a grace payment, grace penalty. Grace period. Yeah, I don't see it. Privacy and access, showing the property to new tenants, personal purposes. Advertising photographs of tenanted properties. We've talked about this. When advertising a property for sale or rent which has existing tenants, owner must gain written permission of the tenants to publish or display images of the property which might identify the tenant or any other person. Yep. Okay, so then it's talking about repairs, maintenance, emergency repairs, reasonable wear and tear. Let's talk about that because that's always an issue. Reasonable wear and tear in general terms includes minor marks and scratches and things that deteriorate naturally. Wear and tear is not reasonable if caused by the tenant, even if it was an accident. For example, stains on carpet and deep scratches on the floorboards are generally not considered reasonable. That's what it says in Tasmania, but you can also talk about crayon marks on walls. That's not reasonable wear and tear that we've heard many times because that can be cleaned. And why wasn't it cleaned, right? Disputes about repairs, water charge, ending a tenancy, termination, breaking the lease. So in this situation, a tenant is responsible for paying rent until a new tenant is found or the end of the date of the lease, whichever comes first. The owner must make reasonable attempts to find the new tenant. So there's not an acceleration clause per se, but the tenant is still responsible for paying the rent amount. Court-ordered tenancy agreement. We've talked about abandonment already. Yeah, automatic termination. If the tenant dies and there is no other surviving tenant in relation to the premises, the agreement also comes to an end when there is a closure order made under Public Health Act 1997. Okay, so this is talking about abandoned goods again. Oh, here we go. So, if a tenant leaves goods behind when they leave the property, the owner may do one of the following things. If the goods are of no value, they may donate or discard the items and sign a statutory declaration that describes the method of disposal. If the goods appear to be worth less than $300, they can sell and sign the statutory declaration stating the method of disposal. If the goods appear to be more than $300, they can apply to the magistrate's court for an order to sell the goods. And if the items appear to belong to someone else, then they have to be bought on hire, purchase, lent, or stolen. Contact the owner of the goods or seek advice from the police. That's probably a good idea. When the owner sells the goods that have been abandoned by the tenant, the money can be used to cover debts owed by the tenant, including any money that is owed to the owner after they left. After the debts are paid into an interest-bearing account, the remainder of the sales money must be left for 6 months. And if the tenant does not make the claim for the proceeds, then within 6 months, the owner must pay the leftover money to the Residential Tenancy Commissioner. And then their costs of leaving early or abandoning a property. Owners may charge to relet the property, but reletting costs cannot be charged if the tenant is evicted. Yeah. Okay, notices to vacate or terminate the lease. Vacating the lease, the days matter in Tasmania. I'm not going to go through each one, but it's very interesting. And it's specific. The days matter. Okay, problems and disputes. And where to get more information. Here we go. Here's our first bit. So if you've got questions, if you are a landlord in Tasmania and you've got questions, Consumer Building and Occupational Services, the Rental Deposit Authority, Office of Residential Tenancy Commissioner, Real Estate Institute of Tasmania, Housing Tasmania, Housing Connect, especially those last two, Housing Tasmania and Housing Connect, are about housing assistance or public housing. But the first four there's website links on all of those, and they all have phone numbers. In fact, they're all the same phone number. Isn't that funny? But definitely, you want to call and talk to these people and just say, hey, I'm a new landlord. What are some of the things, some resources that will help me? Then there's the next one. The next page is about problems and disputes and talking about the magistrates of courts in Tasmania based on your location. So you can call and talk to them, and I encourage you to do so, just even to learn. And then there you can call the Tasmanian State Government Helpline directly, and they also have an email and a website. There it is. Okay, let's talk about pets. This is Consumer Building and Occupational Services Residential Tenancy Amendment Pets Act 2025 commencement. So this is something that I'm recording this on March 2nd, 2026, but this is, you're seeing on screen share, Residential Tenancy Amendment Pets Act 2025 will commence on Friday, the 20th of March, 2026. Let's go through this. Am I allowed to have a pet in a rental property? Only if the owner has agreed and it is in the lease, except for guide dogs. Guides dogs, remember, that's a service animal. They have a job. That's not a pet. Who is responsible for damage caused by pets? The tenant is responsible for leaving the property the same way it was at the beginning, and this means that any pet damage that the pet does is the tenant's responsibility. This often includes damage to grassed areas. Okay, and there's just a ton of sheets here. It says tenant fact sheet, pets in rentals. I'm just going to open this. Pets and rentals, key points. It's talking about how you are trying to, what is a pet? A pet is a domesticated animal or animal dependent on a person for food or shelter. Yeah, uneligible animals. The following animals are not pets: an unregistered dog over 6 months of age, an unmicrochipped cat over 6 months of age, with an exception of a requirement of being microchipped through a vet. And you can refuse, an owner can refuse to consent a tenant keeping a dangerous dog, especially if it's causing issues or people are changing their normal habits because they want to avoid an animal. That's happened in my place. We've had bites and everything. So there's phone number and an email, but there is just a ton of resources on how to do this. Key points. Tenants can request the consent of property owners' agents to keep a pet, and they cannot, owners or pet property agents cannot unreasonably refuse a request for consent. Yeah, you've got to really dive into this. This is about to be real. In fact, March 20th, 2026, you've got pets in Tasmania. Okay, let's go to one of the other ones as well because it's saying property owner fact sheet, pets in rentals. Let's do that. So this is an amendment. This is the property owner information. Key points. Tenants have a right to request, they have a right to request permission to keep a pet, and you as the owner cannot reject rental applications just because the applicant intends to keep a pet. Properties owners can only refuse on specific reasonable grounds and must apply to the Tasmanian Civil and Administrative Tribunal, TASCAT, which within 14 days if they wish to refuse. If you do not respond to the tenant's application within 14 days, property owner is taken to have consented to a request. You must know this. You and the tenant can agree conditions for keeping the pet. You cannot increase the rent payable by the tenants or require a security deposit before allowing a tenant to keep a pet. So you cannot charge pet rent, you cannot charge additional deposit, but this just goes on to residential. It goes on to the tenant to maintain this and to give the unit back at the end. There is a little bit more about this, but when you apply, if you're going to refuse this, then you can say, I'm assuming that you can say that no, they've got, 6 dogs and no, that's too many for a 1-bedroom apartment. Like it's whatever it is unreasonable, or maybe you can't get insurance because of the dog breed. I mean, there's lots of different things, or maybe they want to have a puppy breeding, right? And so that doesn't make sense for what you're doing. It may impede on other tenants around that unit, right? So you might call Tasmanian Civil and Administrative Tribunal and ask them on what grounds you could potentially deny this. I personally am pet friendly, so this is a new thing for me, seeing this. Request to keep a pet on residential premises. So this is the document for this. Oh my goodness. So this is how you actually do it. The tenant would apply for this type of it. Pet decision. Okay, so that's the task app. Okay, look into that more. And I do have that as a specific hyperlink on here. This is Tasmanian Legal Aid. And so if you've got a question, you've got concerns, applying for legal aid, going to court. Now, this, of course, is not just real estate. This also applies for other legal things like family issues, etc. Okay. Tasmanian Residential Rental Property Owners Association. Here is a group that you could potentially join. You could look into. They might have events. Who are landlords? I encourage you to contact them and they have about join us. Let's see what they say on a join us. Annual membership is $50. Seems like it is a very reasonable fee. It's not like it's 1,000, it's $50 and it might have some good places where you can actually learn a few things, right? So here we go, $50 a year. Introduction to Rental Ownership course, Managing Your Rental Property course. This might not be a bad idea if you're a landlord in Tasmania and you are not a member of this. You might consider doing that. Also, there is a tenants union of Tasmania. I am actually involved in a number of tenant unions because I like to understand the conversations going on. And I'm surprised they don't have more about the pet thing on here, but that's okay. Our services, legal representation, contact us, board, tons of fact sheets. Oh my gosh, lots and lots and lots of fact sheets talking about tons of things about bonds, mold, notice to vacate, don't panic, water and sewerage charges, download forms, and all those are free. So take a look. Tasmanian Bar. I always throw this in here in case you are looking for a legal person, a solicitor, a barista of some kind, a barrister. You need some legal advice. Sometimes a barrister will do like a consultation for a reduced charge if you're only going to talk to them for about half an hour. But I would recommend that you go to legal aid first and talk with them. So here's some resources, bar council, how it works, the law library. Yeah, I would just take a look. And I think that's the last one. Okay, so what I'm going to do is I'm going to stop screen sharing now. Stop sharing. Here we go. And I'm going to go through the bingo card for Tasmania that we've seen, and not all items were addressed. So this is kind of interesting. So this is for Tasmania, just reviewing this. So owners or agents cannot charge general tenant application fees just for applying. We've seen that in advance. They cannot charge it, but an owner can charge a holding fee. Lawful upfront charges at the start of the tenancy are limited to a rental bond up to 4 weeks rent, is what we've seen. Rent in advance of the first payment period and a holding fee if the owner agrees to hold a vacant property for more than 7 days. There is no statutory grace period in which rent can be late without being breached. Rent is due on the day and frequency set in the lease. The Act does not set a specific late fee formula, whether it's a percentage or a flat amount. Any fee must be in agreement and cannot be unlawful penalty or extra entry costs beyond what the Act allows. And so this will very likely need to be in your lease agreement with your tenant. If the rent is unpaid, the landlord may issue a notice to vacate. Security deposit slash bond. The security deposit is a rental bond, not a simple informal deposit like it is in North America. Maximum bond is 4 weeks rent for most residential tenancies, and it must be lodged with the Residential Deposit Authority, and it's not held by the owner. You've got to make sure you do that, and the program is called My Bond. Lease wording, signed copy, and delivery. The lease, residential tenancy agreement can be written, verbal, or partly both, but using standard written form is strongly recommended. And if you've been listening to this show, if it wasn't written down, it didn't happen. So I strongly recommend you do a written lease. Written lease should include the parties' names, premises, address, term. It's typically fixed term, rent amount, payment details, bond amount, standard terms, including utilities. The owner agent must give the tenant a copy of the signed tenancy agreement and any attachments within 14 days, and the completed condition report, 2 paper copies or 1 electronic copy, which they both have to sign. They don't both have to do, but they both have to sign it. There is no general statutory requirement for a tenant to provide an emergency contact, but it is best practices for any landlord to have an emergency contact for every tenant in the event of abandonment, incapacity, or death. But a lease may ask for a contact person. This is contractual rather than a specific statutory obligation. Tasmanian law does not impose a separate statutory pet bond or pet rent, but as we've seen coming up on March 20th, 2026, the rules on pets will change. You cannot charge an extra bond or security deposit for pets. Condition reports, we talked about this. At the end of the tenancy, the tenant should complete an exit condition report and give a copy to the landlord. and they either can make a claim for the bond. The tenant can make a claim back for the entire bond, but the landlord, if the damages are beyond normal wear and tear, they can make a claim for that as well. But remember, the authority is holding this amount, holding this bond, right? So you've got to make sure you have your ducks in a row, and all your days matter. All your days matter. Standard notices are warning wording. Formal notices, notice to vacate, rent increase notices, breach notices must be in writing and contain required details. And the Tasmanian Standard Residential Tenancy Agreement and Government Rental Guide provide model wording, which is what we've gone through in the hyperlinks. They should be followed. Rent increases cannot happen more than every 12 months from the start, extension renewal, or last increase in residency. Proper written notice is required before a rent increase takes effect. And there is no fixed statutory percentage or dollar cap for the rent increase amount. The increase must comply with the act and may not be unreasonable, or they say unconscionable. Renter's insurance. Nothing said about renter's insurance. Abuse of access, right of entry, as they call it in Tasmania, was defined. Landlord retaliation was not defined. But retaliatory conduct such as increasing the rent, issuing notices, or reducing services because a tenant exercises a right, such as requesting repairs, complaining to authorities, can be challenged again at the Tasmanian Civil and Administrative Tribunal that can review such actions under the Act. Leases in Tasmania are fixed term tenancy, which continues to the end date and generally cannot be terminated unless there's a breach or mutual agreement. And then when a fixed term lease ends, if the tenant remains and the parties do not sign a new fixed term, the tenancy usually becomes a periodic tenancy on the same terms subject to the Act. But you've also got to make sure that you are reading the fine print when it comes to an end of a fixed lease. The standard Tasmanian tenancy agreement does not automatically include a pure acceleration clause. However, a tenant is still responsible for the remainder of the rent on the lease until or unless a new tenant is found, and the owner needs to chime in on that as well. At the end of the move out, the bond is only used for lawful purposes, including unpaid rent, damage beyond fair wear and tear, cleaning, if not reasonably clean, and other proven breaches causing financial loss. Tenants cannot insist that the bond simply be treated as last month's rent, because it's not. It's all money, but it's not a rent, unless the parties expressly agree and it is compatible with the bond lodgement rule, which I don't know if it is or not, but typically in this, now they're holding the deposit in a separate bond. It's very likely not able to be used as rent. Okay, non-payment of rent or utilities, mischief for other breaches, and abandoned items. We talked about abandoned items in all of this. So I think, let me just make sure we've got it all. Pet bond, Nope, that's it. We're coming to the conclusion of our location-specific episode on Tasmania. Each of my location-specific podcasts is set up in the exact same way, answering the same 4 questions. 1, what are the basics of that location? 2, what are the nuances of that location? 3, what are some guidance about abandoned items left behind by a tenant? And 4, where to get help in your local area in Tasmania. And as I did that, you saw me keep track on my bingo card of standard items I see most often in tenancy laws in different locations, which helps as a summary for this one. This is the same format for every location-specific episode. So if you're interested in another geographic area, you already know how I'm going to do the framework. You already know what I'm going to talk about. Just change the location. But again, this episode is not all-inclusive. You must research further in your specific area, including your county, regional district, parish, city, other governing document, municipality, whatever may apply to you that involves your rental location. But today will get you started. Now, if you're listening to this podcast, chances are that you're either new to real estate or you want to be new to real estate in the Australian state of Tasmania. Things you can do to help yourself is to get deep in the weeds about the Residential Tenancy Act and all of its changes and fact sheets. The other thing you can do is check out your local meetup groups, whether online or in person, near where you are. Now, how do you find those, you might ask? Well, you can jump on social media, start asking questions of other Tasmanian landlords or the like, and ask questions. And if there is no meetup groups, you can certainly meet with them virtually, right? But I hope you enjoyed today's show about the Australian state, Tasmania. Don't forget to subscribe for more expert advice and real stories from across the rental property world. I'm recording this episode today in San Antonio. Where do you want real estate to take you. Join me in the next episode live right now in the library, episode 224, all about Utah. I'll see you there.